Bonjour, Kinamagi and Ireland edition of Cas, and welcome to this episode of Social Studies Explorer. Today's episode, Supreme Court nominations. You have with you a packet beginning with this page, Supreme Court nominations, and we're going to talk a little bit about the Supreme Court, which is the highest court in the land. We're going to focus on the process from which a candidate is nominated and becomes a Supreme Court justice or is rejected by the Supreme Court. There will be a section at the end with a few questions to answer, and there is also for your information where you could go above and beyond and dig deeper on one of the nominations that was scuttled. So, new justice in the branch. The judicial branch at the federal level is made up of just 9 people, the 9 justices on the Supreme Court. These 9 people are appointed to the court for life, and together they make decisions about issues that act as law for all Americans. Often, these decisions have a direct impact on people's everyday lives. When is it okay for law enforcement to search your car during a traffic stop, or search you if you're stopped while walking down the street? Can a state ban certain types of guns? Does the Constitution guarantee same-sex couples the right to marry? With these kind of issues at stake, it's easy to see why Americans pay attention when there's a vacancy on the Supreme Court. Who is this person who will become 11% of the judicial branch? Are they qualified? Are they fair? What are their political views? And will they let those views influence their decisions? In the United States, we expect our judicial system to be impartial and above politics. But when it comes to choosing someone to sit on the Supreme Court, that expectation is on a collision course with political reality. Eeny, meeny, miny, mo. Filling a vacancy on the Supreme Court starts with the president nominating someone for the position. The Constitution doesn't list any requirements for Supreme Court justices, but even so, there are factors most presidents consider. For one thing, the nominee can't become a justice without the Senate's approval. So is the person likely to be confirmed by the Senate? Do they have the right qualifications and experience? Are they well respected? Do they have a record of fairness? Presidents look for a yes answer to all of these questions. They also look for possible pitfalls. Is there anything controversial about the person? They've been a judge. Do they make any rulings that seem biased or wrong? Do they hold extreme views? A yes answer to these questions can knock someone out of the running. However, in recent years, as it's become more hyper political, a yes answer to some of those questions may not knock you off, nor would a no answer to one of the first group of questions. Experience needed. Given the court's role, Americans expect Supreme Court justices to be extremely qualified for the job. Technically, the president can nominate anyone to the Supreme Court, but legal thinking requires specialized training, so a president is unlikely to nominate someone who hasn't been to law school. Even though justices don't have to have a law degree, so far every single Supreme Court justice has been a lawyer. Most have also had experience as a judge, especially in the United States Court of Appeals, which works a lot like the Supreme Court and requires the same kind of thinking and analysis. Nominees might also have experience as lawmakers. Lots of elected officials are also lawyers, government attorneys, law professors, or other top-level legal positions, even one former president. Presidents are also consider how the nominee would affect the court's diversity. This isn't just racial or ethnic diversity, although that's one consideration. It includes gender, religious, and geographic diversity too. Are women well represented on the court? Do the justices come from different regions of the United States? Do they represent a variety of religious backgrounds? Achieving or maintaining diversity in the court isn't the main factor in choosing a nominee, but it is a factor. Depending on the president, it could be a larger factor than for others. And not all demographics are represented in any way on the court. On the picture on the left, you have Thurgood Marshall, the first African American justice appointed to the court. Supreme Court nominations. Politics in the court. Unlike Supreme Court justices, the president is elected to office by citizens who expect the president to carry out a political agenda. Because of the court's impact on major issues, the opportunity to nominate a new justice can feel like winning the lottery for the president's political party. Party members are anxious for the president to choose someone who will decide cases in a way that jives with the party's ideology. But let's be clear, judges at all levels are expected to set aside their personal and political views when they're behind the bench. They are supposed to apply the law fairly to the unique situation involved in the case and apply the law as it is, not as the judge wants it to be. They do this using the legal analysis and principles of law that are the same no matter what the case is about. The problem is, judges disagree about the proper principles and types of analysis, and each Supreme Court justice may approach the exact same cases differently. This can result in decisions that appear very political. Judicial philosophy. The Supreme Court's whole job is to interpret the law, especially the Constitution. So the process of nominating a new justice is hyper-focused on the nominee's ideas about how the Constitution should be interpreted. This is called judicial philosophy. It's no secret that there are liberal and conservative justices on the Supreme Court, but in the judicial context, these labels have a special meaning related to the way a judge interprets the United States Constitution. Those with an originalist philosophy want to figure out exactly what the founding fathers intended when they wrote the Constitution in 1787. Those who are textualists look only at the text of the Constitution and try to give it common sense interpretation without looking at other evidence, such as what the founders or lawmakers might have intended. On the opposite end of the spectrum, people who follow the living Constitution theory prefer to interpret the Constitution in the context of modern society and values, recognize that today's world and the world in 1787 are very different. Originalism and textualism are considered conservative, while the living Constitution theory is considered liberal. But beware, this doesn't mean that judges using these approaches will always arrive at a politically conservative or liberal decision in a case, although they often do. Also, judges don't normally cling to one single philosophy. Most often, judges develop their own personal approach and will use several tools of interpretation in order to arrive at a decision. President, politics, and the people. Most nominees have a record of judicial decisions or other actions that reflect views similar to the president's because, let's face it, every president hopes to tilt the court in either a conservative or liberal direction. A judge's judicial philosophy can often predict how the judge might decide a certain issue. So generally, you'll see a conservative president looking for a nominee who does not follow the living Constitution theory, while a liberal president will look for one who does. Most Americans don't have legal training, so they don't have a behind-the-scenes concept of the different philosophies of constitutional interpretation or how judges arrive at their decisions. Because of that, the process of selecting a new Supreme Court justice stays on the level of politics for most people. Would the nominee vote to overturn Citizens United? Would the nominee rule on immigration cases? It's very common to judge Supreme Court justices based on how they voted in cases related to political issues. The fact that the court's job involves hearing cases about these issues makes the court seem more political than it actually is. Political path, and you can see the path on the left here: nomination, investigation, Judiciary Committee hearings, the committee votes to recommend the nominee, Senate debate, Senate confirmation, sworn in. The process of choosing a new Supreme Court justice, however, is political almost every step of the way. The president nominates someone, so that's political. Once a nominee has been selected, the media hashes and rehashes the person's background, speculates about the nominee's ideology and views, and guesses how liberal or conservative the nominee's votes on the court might be. The Judiciary Committee holds hearings where committee members fire questions at the nominee and explore every detail of his or her qualifications and judicial philosophy. It's super stressful and it's televised. And it's the Senate, so it's political. The committee may try to corner the nominee into committing to a position on a controversial issue, such as how the Second Amendment should be interpreted. Nominees avoid answering these questions because our justice system relies on judges approaching each case impartially. However, there's enough information in a nominee's background to give the committee a strong sense of where the judge would likely come down in a case dealing with a particular issue. If not, that can be a problem too. Senators' careers revolve around political issues, so they are very concerned about the political consequences of appointing a particular nominee. And there have been cases where the Senate was sure that a person was going to follow one of the ideologies, and in fact, turned out they didn't. Next, the entire Senate debates whether to confirm the nominee. Senators get up and make statements about the nominee, and since senators are politicians, their opinion of the nominee is political all by itself. My constituents are going to love me for supporting this nominee. May also slip in a few politically motivated extras during the debate. While I'm on the subject of the nominee, let me remind everyone that I firmly oppose the president's recent executive order. So the senators are always going to turn this into politics on both sides. Finally, the entire Senate votes on whether to confirm the nominee. Each senator knows that all eyes back home are on their vote, so the way the senator chooses to vote can be a political move, and it frequently is. Most fun, not fun, but necessary. As most nominees, and they would probably tell you they'd rather not go through such a stressful and invasive experience. While they would certainly defend their judicial philosophy, they would disapprove of the parts of the process that make them seem aligned with a certain political view. And no doubt they'd rather skip the part where the media scrutinizes every detail of their private lives. In the case of Clarence Thomas, even searching his garbage cans. The nomination and confirmation process is spelled out in the Constitution, so America's founders wanted both the president and the Senate to be involved. It's how the executive and legislative branches exercise checks and balances over the judicial branch. Despite the political posturing, nominees are very aware that as a Supreme Court justice, they have a responsibility to stay above politics so Americans can have faith in the independent judicial system. And in the recent couple years, we have seen some very testy Senate hearings that have gotten very, very personal. And while this video won't go into too much detail nor prescribe the rights and wrongs, it is obviously very hyper-partisan at this time. And let me adjust this slide to where you can see it. Some recent nominations. This does not include the most recent one, where Ruth Bader Ginsburg was replaced. But prior to that, we have Brett Kavanaugh and Neil Gorsuch. They were both nominated and approved. And you can notice that there were more Republicans. And Gorsuch got a few more votes than, well, they got at least a few Democratic votes. Merrick Garland did not get a vote. That's one of the examples where the Senate can be hyper partisan. And as you'll notice on one of the Dig Deeper pages at the end that you're allowed to do, Merrick Garland never even received a hearing. Senate Majority Leader McConnell decided that we would wait till there is a new presidential election, which in itself was a very, very controversial move. For that, then we have Elena Kagan, Sonia Sotomayor, Samuel Alito. Then we have another one who withdrew when it looked like they were probably not going to be approved. That was Harriet Miers. Then we have Chief Justice. In fact, you can see here with the chart, once Harriet Miers was not approved, Samuel Alito was. John Roberts is the current Chief Justice because he replaced the former Chief Justice, Rehnquist. You can see Ruth Bader Ginsburg, who recently passed away, and it's all by president. We know that we have Robert Bork, who did receive a vote, but did not win. And if you notice that with a few exceptions, during the 80s and 90s, they were pretty lopsided votes. Antonin Scalia, very much a conservative, 98-0. While only the Republicans only had 53 votes, they still managed to get 98. Robert Bork was defeated. We have Anthony Kennedy, who recently retired, 97-0. 90-9. Clarence Thomas was a much more controversial case, as mentioned. That one was close, but even in here, it was still running pretty close. Now let's flip back to the page here. Too far. We have some nominations questions for you to look at. These will be either done as on paper copy, or there will be a Google form. And then we have some of the others that you could choose to look at, and this is optional. If you do it, it is digging deeper, so it's using some of those higher order skills. You're welcome to look at one or more and turn it in, but you're not required to. We have Robert Bork, Harriet Myers, Clarence Thomas, who was approved, and Merrick Garland, who you may recognize now as the Attorney General of the United States. If you have any questions, please reach out to me at mireland@sagchipschool.net. As mentioned, if you're in class, the paper copy will be turned in. You are also welcome to try one of the additional copies. If you're at home, you're going to submit the Google form, and you could look up the stuff on one of the extra information, but you don't have to turn it in. Have a minwa, Bama P.